that it be repealed. Unfortunately, it was not. So whatever was published still has the Land Control Act, which manages agricultural land. This particular law had its uses because, of course, food security is linked to the amount of arable land. If we build up the whole of the country, there'll be nowhere to have food. So usually, especially arable land, like in the bread baskets, that land has to be controlled on its usage. Number two, also how you subdivide, how small units you can do it. I think a good example is Kiambu, where previously it had coffee farms and tea farms, and now, because they changed the nature of it, it was done a change of use that now it moved away from agricultural land, and then now it has become residential and commercial. Then it can be subdivided into smaller units. So these are the kind of things that you need to know. Also, Land Control Act requires you to get the consent within 6 months of your transaction. Most of these boards sit once a month, and you are required to be there physically, both the buyer and the seller. So another aspect, of course, apart from that, there's the consent of the head lessor. This applies to leaseholds. This is whereby if it's the government of Kenya who has given you a lease, you need a consent for that. If it is the municipal county, you need a consent for that. So all these consents have a fee attached to them, and they are also approved, and they are also based on full payment of land rent, because land has land rates, which is for a freehold, and then land rent, which is for a leasehold. So now I was advised that we have some investors. So for foreign land tenure, this is also an aspect that has been clarified in our constitution, whereby it has now limited the period that a foreign person or a foreign entity can hold land in Kenya. This is in Article 65. It's quite controversial because previously the argument was, as long as the company is Kenyan, then they should have Kenyan rights, and it doesn't matter who the directors are. Right now, if even one share belongs to somebody who is not a Kenyan citizen, that is deemed as a foreign company and for purposes of land registration. What this means is that they cannot hold a freehold property and can hold a leasehold. For the leasehold, because it's foreign owned, it has when you want to renew it, which is mostly after 50 years or 99 years, it is not automatic or guaranteed like it would be for a normal citizen. The idea for this is that anyone who is investing in land in Kenya from outside the country is required to make good commercial use of the land, so that by the end of 99 years, you'll have recovered whatever you had invested there, or within the 40 years or the 50 years. So what this means is that issue of absentee landlords and idle land, valuable idle land, will no longer be there, which I think is good for our country. So there's something to note that when you're holding a leasehold and you have 30 years or less, your property becomes less attractive to buyers, especially those who are using financial instruments and those who want to do multiple dwelling. Why? When you're doing multiple dwelling, you want to give people leases of 99 years or more so that it's commercially viable. And 99 years technically is father and son, right? So it's the grandchild who will still be there when you're done. So those are already 2 generations will have utilized and gotten a benefit from that land before you need to invest again to the renewal. So when you have something of less than, actually commercial entities will not charge or use it as security if you have less than 21 years or even 30 years now. So as a landowner, you need to keep an eye on that. And you can do a change of user and you can surrender your lease to get a longer term, which will make it more economically attractive. Usually for normal pieces of land, you start the process of renewal in the last 5 years. I know it sounds like it's a long time ago, but where I am in Mombasa, a lot of the land was issued in 1904 by the colonial governments, and a lot of those leases expired. And people were very shocked how land went back to the ancestral owners and to the original owners who had owned the land, or the government. Or even, as we have it here, the trusts and the Waqf are the ones who had it. Another new thing which has come, not so new, is the Sectional Properties Act, whereby it is now mandatory that any multiple dwelling shall have a title for each unit. This, for me, is a very good tool that is securing your rights as an owner and allowing you the flexibility to use it. Yes, to use it for whatever purpose you want, and even to dispose it. Because previously, when you were connected to the owner of the land, connected to the management company, it was not so easy for you to sell. And many developers used to hold on to the main land and force you to pay crazy consent fees before they allow you even to charge or to transfer. So I think for me, this is a very big improvement and has made apartments more valuable, because now they are a useful tool and you are able to use them as security or just sell them as a single unit. Of course, the existing units were supposed to be converted within 2 years. This may not be practical because there is the geolocation that has to be done. What is happening right now, many complexes are having that challenge, whereby when one person wants to sell and they request for the sectional property, it becomes a different story. So those who are owning or managing management companies, it's very prudent. Just get it done. Register your property with the maps on the Ardisasa or at the lands office, so that you are able to utilize your apartment. And when you want to sell it, it's simple. You don't want that when you want to sell it and you have a buyer right at your doorstep, you're like, oh, unajua, I have to go and do this for 6 months before I'm able to do that transfer. So that's why we always tell people who own land, don't just sit pretty. Nowadays, you have to make sure you're ready to transact by making sure all these things are done. So similar to how we used to have management companies, now we have management corporations. The goodness is that these ones now, it's much easier and it's not dependent on an individual. And even when people refuse to cooperate, there are ways that the government can step in to help, especially with the service charge and all that, so that your asset is not at the mercy of other people. Finally, we can just go through a brief conveyancing checklist. The life cycle of any transaction on land is about 3 or 4. We start with the pre-contract. First of all, who are you engaging with? I know that sounds like a funny question, but as I've said, number one, the person on the title is the only one who has a right to transact. So if I'm holding my sister's title deed, I am not the one able to transact unless I have a power of attorney that is registered on that title and in that registry where the title belongs. So coming with a power of attorney from a different region, you still have one more step before you can legitimately transact in that land. Many registrars are wary of this because a lot of older people or people who are not educated have been taken advantage of, and many of them will insist that the owner has to come or communicate with them if they are outside the country for them to be sure. So power of attorney is good, but it's not the best. The best is to have the person on the title to be the person who is transacting in their piece of land. This is also very important in land held by somebody who is deceased. You do have to go through the succession process to the point of confirmation, and you do the transmission to the beneficiaries. Some registries are not agreeable to allowing administrators to transfer. In fact, the court has said that an administrator does not have a legal right to enter into an agreement. You're supposed to deal with the person who is the beneficiary Or, for instance, where they're selling for an immediate need, you get a court order to allow the administrators. So also when you're dealing with land for estates, be wary of who you're transacting with. Then finally, with companies, always do a CR12 check to make sure that if it's a freehold, there's no foreign owner, there's no foreign shareholder in it before you start. So if at all you want to, just make sure by the time you're getting to the agreement and transfer stage, there is no foreign owner for a freehold, and for a leasehold, there's no problem. Everybody can hold. Now, another thing right now, for the properties that are digitized, you need to have an RDSASA ID because the transaction will be done on RDSASA. And also that means that whoever is transacting, the entity must have a PIN. Of course, as a buyer, you must do your search. As I said, right now, you need to go the extra step and get what is called the certified copy of the green card, where there's a green card, or a certified copy of the title deed. You have to go a step further and get the parcel file from the point of allotment. You get a certified copy, and even do a search at the adjudication to confirm that this was adjudicated land that was converted. Or you go to settlement and confirm all that. So you don't have to worry about this as an individual. This is why lawyers are there, and they can assist you with this. For the land, one of the tricks they used to do is they find a certain piece of land is not alienated, which means there's no title on it. So they cut it into many pieces. So for instance, the big piece was called 001. They cut it into big pieces called 10, 11, 12, 13. So if you look for 001, it will no longer exist. But that 10, 11, 12, 13 was previously 01. So that kind of information, your surveyor is able to help you work backwards from the beginning of how this land was delineated, because as I said, right now, the standard has become very high that even if the subdivisions were not done properly. Recently, I had a matter where they skipped a step in the mutation process and the subdivision. They didn't get the land control board consent, and they went straight from the owners, and they registered the subdivision straight to the buyers without transferring to the owners first. So you see those kind of discrepancies that used to happen. Right now, it can be a challenge to the purchase. Now, where the danger is when a father sold or a mother sold land without the kids knowing, and they want to get it back. This can be a loophole that can be used, and you'll be forced to come to court to justify your ownership just because some steps were skipped. So we always tell people, don't skip any step. The land transactions have several steps. Some even have 20 or 15 steps that you have to go through to reach the end. Just make sure whoever who is doing it for you or yourself, you make sure you dot all the I's and cross all the T's. So that then on the contract stage, of course, your document has to be witnessed by a qualified lawyer. You need to check the LSK portal, make sure they are witnessing your document when they are licensed. These are the kind of problems that can come around. So we come to the completion stage. This is now when you want to take your documents, the completion documents, the lands office. This includes land rates, rates clearances. The property has to be converted to a sectional property if it's multi-dwelling. You have your lease. Now, on the lease, we've encountered very many people who have a lease certificate without the terms and conditions of the lease attached. The previous title deeds were fairly straightforward because they were typed on the same title documents. But the smaller titles, the RLA titles, it was a separate document, which was normally not stapled or attached to your title, certificate of title. So if people didn't keep it well, it is prudent to get a duplicate from the lessor, whether it's the government of Kenya or the county, to have it because it has the conditions that allow on the usage and all that. So those are some of the things which you need to make sure are there. Then, of course, you take your documents to the lands office and you go get them valued. Right now, most valuation is done online. What this means is that like properties will be valued at a similar price. So even if you bought your land at 1 million shillings and your neighbor sold this neighborhood at 5 million, the property will be valued at 5 or a higher figure based on the purchase price. But it can never go lower than the last transaction in that area. And the valuers now are required to come on the ground to confirm what kind of structures or what kind of an area is it, so that we now cannot say ni mashambani when it is actually a commercial center. Also on the completion stage, if you are buying a built-up property, you need to make sure all approvals were given. This is very important, especially on the setbacks, those who are living next to water masses, next to roads, to make sure that property will not be pulled down. We remember when Kibaki's government came in and the buildings were being pulled down, we were very shocked. But those were road reserves that were already there, and those people were not compensated. So to avoid that, just make sure before you buy, you have made sure that property it can be transferred, because remember now the burden is on you. Then finally, after you do your transfer, you have to pay your stamp duty, which is 4% in commercial areas, or rather in urban areas, and 2% in agricultural areas. And for the seller, you have 15% tax. 15% tax is only on the profit or the gain. That's the difference between the price you bought, whatever you invested, supported by receipts, and what you have sold at. So it's basically the profit is what you pay tax on. There are exemptions. For instance, if it is your home, and then also for stamp duty, there are exemptions if you're buying under national housing, under the housing projects, and if you're just transferring to yourself, as in you're just restructuring from an individual to a company, a family-owned inheritance, there's no stamp duty. But all other transactions, even if you're transferring to your own child, right now, without converting to a company, you are going to pay stamp duty. So that's what I would say. You need to, at the gray areas, let's just say there are the areas that can put you in a little bit of confusion. So as I said, just to wind up, the good thing is land rights now are more clear. They're more distinct. They've been defined well by our constitution. And we have the acts and the regulation which come in to make sure that those rights are exercised well. But now you have to be very vigilant, because it's a limited asset. So you have to protect it, and and it's very valuable to everybody else, including the government. So it's good for you to have your paperwork in place and to also not allow your land to be idle. I think that's something I should mention about acquired rights, like what do they call it?
Adverse possession.
Adverse possession. Yes, it slipped my mind. Thank you for that. So adverse possession is something that it can make you lose your land because you're not using it. And as we've said, land is finite. It's only limited to our boundaries. We can't, anything beyond our boundaries is no longer Kenya. We cannot access it, right? So you need to protect it, and most importantly, to be using it. If you're not using it and somebody else uses it for 12 years without you interrupting them, they can go to court and acquire the right. So just to make it clear there, it's not automatic. You have to go to court to acquire the right for the piece that you are using. So if you squat on 12 acres and you're only using half acre, you'll only get the half acre unless you use the whole 12 acres. So, the land space is very dynamic. There are several pieces of laws that govern it. My only advice to people is get people who are conversant with how the systems work, get people who are actually qualified and registered and can give you the correct information, that when you are forced to defend your title, you have all the ammunition. Thank you.
Thank you so much, Janet. That was a good presentation. Thank you so much. And I think we've not even covered everything. We've not had enough of everything. But thank you so much. I think now and messages. There's a lot of messages that are coming in. I don't know whether you're able to read them.
Yes, I can start with Steve Taylor. He's asking what's the difference between a search, green card, and mutation. So a search is an application you make to the land registrar asking them to confirm the registered owners and whether there are any encumbrances. As I said, for some the digitized titles, you can do this on Adisasa, but otherwise you fill an application form and you get that information. So the only information they'll give you is the name, and if there's maybe the size, the location, and if there's any encumbrances like a charge or there's a court order. Now, a green card is the record that the lands office used to keep in the old system. Once it's digitized, the issue of green card is no longer there. It will just be called the record. So basically, the green card is where the land registrar records physically any change. If there's a transfer, if there's a charge, if there's a caveat, if there's a restriction, that's where it is recorded. That's why I said you need to check, get a certified copy of that green card for you to know what is the history, because each entry is numbered sequentially, one to the last. Okay? Because what they do for green card, it's put in a thing called a Kalamazoo or in their parcel files at the lands registry. This is their recording system. A mutation is an instrument used to change a piece of land. For instance, when you're doing a subdivision, when you're subdividing one piece of land into several pieces of land, there's a document called a mutation, which is filled by the landowner and the surveyor to confirm that you're allowing your property to change. This also applies when you're consolidating. I hope I've answered that. And mostly, if this land is agricultural, it needs to go through a land control board process as well. But the document that changes the land from one piece to several or from several pieces to one is called a mutation. What is the registration? I think let me skip that one because I'm not sure about the facts as of now, because every day somebody comes with a different version. Okay, then how can one know the value of their land after having their boundaries well defined by a licensed surveyor? Thank you for that question. I forgot to mention this other person who needs to be your team, and that is a registered valuer. So a registered valuer, which is similar to the person used by the financial institutions to ascertain that value of land. Land may have sentimental value or look like it is very unique, and you give it a value based on your feelings and emotions. But a valuer is able to give you a market rate, and they have their methods of calculation, which are standard. Even the government uses similar standards. So for that one, of course, for the bank, they do market rate plus market price plus forced sale value, which means the lowest amount you can get if it's supposed to be auctioned. Yes. So, yeah. Okay. Employee scheme, yeah, the valuer. Yes. Let's, we have a lot of people who are registered valuers. Let's engage them. I find it very useful that when a client wants to sell a piece of land, I always advise them, get a real valuation so that you know how to negotiate. Don't overvalue and price yourself out, and don't undervalue. So the due process cover, the due diligence process, as I've mentioned, it covers root of title, which means the history of the delineation of this land. That means from the time it left the government to enter into private land. How did the process start? Did you get an allotment? Did you get an adjudication? Did you get, were you in a settlement scheme? How did you get this land? Then from there, you work backwards. If it was subdivided, how was it subdivided? Right? Were the necessary approvals given for it to be subdivided? Okay. Then for this, you need to use the maps, the survey maps, as well as the records at the lands office. So that's what I would say about the due diligence. But I've also mentioned some encumbrances may not be seen on the face of the document. So even the registrar might not know that there's a court case about this land. So you'll also have to counter check with the courts and other agencies. So what we are hoping is that with the digitization, it will be easy for any case that is attached, you're able to match them much easier, because right now you have to go to different offices just to figure out what is happening. But with the digitized platform, it will be much easier to do the due diligence process. Then, yes, can developers, actually, most developers do the sectional title before after the project is complete, so that they have the titles ready for the owner. So this requires the surveyor to come and do the georeferencing, and then they're able to issue. This ones, I think the project needs to be completed before they can do the sectional titles. Thank you for that, Bernard. What happens if I buy a property that has a loan? Oh, thank you for this question. So this is one of the encumbrances, which may be registered on the title. So some people, as I told you, may not register the loan officially on the title, but they have a lien over it, which you may only discover later. So the first thing you ask an owner, does it have a loan? Does anybody have a charge or a lien? Thankfully, right now, for companies, it's easy. On BRS, you're able to check because they are mandated and required to register those things. But for an individual, sometimes it may not be possible. So when it comes to a property which has a loan, the financial institution has to give a discharge of charge, which is an instrument which you register in the lands office. The financial institution will not give this if their loan is not fully paid. So when there is a loan, we normally put it in the agreement. It has to be disclosed. You put it in the agreement, and then you bring in the financier with to give an undertaking that once they are paid this sum of money, they'll release the title. Because when you have a loan, the physical title deed is with the financier. So you're not able to take the lands office to register. So even if you have a loan with various pieces of property, they can do what is called a partial discharge, whereby if you have 5 titles for 1 billion, they just take away one title, then they say you paid 200 million, you will clean this title, we remain with the 4 for the loan. So that's another advantage of why you should have many pieces so that you're able to be a little bit flexible. Otherwise, without the financial institution's approval, there is no transaction that can take place. And they have to do a discharge of charge and sign and to be registered at the lands office. My contacts, yes, I will. My law firm is Katisya and Associates. My email, info@jkadvocate.com. Then my number for the office, 799-849-228. But my personal number is 0714-411-452. And I'm available during working hours, except today. Then, tax obligation of an agent broker earning commission. Wow. This one is nice because, of course, I think anybody who is an agent knows that you have to be registered as an estate agent, right? For you to charge. Many times people do agency work when they are not registered, which I feel is not right for your industry, because a lot of people are coming in, they don't care about their reputation. They do what we call hit and run. They do one big deal and they disappear, leaving you with all the messes you can imagine. But when you're an estate agent and you're paying for your license and you're paying the taxes, you will protect your business and protect your name. So you will go through all these steps and also work with people who can help you make sure that whatever you're selling is worth it. Because number one, if you sell a title that is not genuine, that makes you a fraudster. You are part of a conspiracy of acquiring money for something that does not exist. So you and wash, same category. So to avoid those kind of things, it's always good to be ready. Yes, because you're selling air. So it's just air through a paper, but it's still air you're selling. So to avoid yourself entering into such messes, you have to do your due diligence. Right now, we know the KYC you're required to do under anti-money laundering and under terrorism. You need to comply with that. And yes, once you do all that, at least you'll be a bit safe. Now, your obligations, of course, you have to pay your, is it 15% on your withholding tax? The person who is paying you commission will do the withholding tax, then you pay your commission. So it depends how you structure your business. Either you'll pay it under income tax or you'll pay it under the 15%. Yeah. Okay, what else is there? Yeah, so brokers and agents, make sure you're working with people who take care of you. Yeah, valuation, thank you for that. 5% is the agency. Okay, yes, that for the agent is 5%. Thank you for that, Veronica. So what role does a lawyer continue to play after the developer has acquired the land and construction has already started? Well, after you've built, you have to sell. So, of course, in the selling, you are there. And maybe I didn't understand that question, because once it depends what are you there for. Because there's always the maintenance, there's annual rates that need to be paid. They have to make sure insurance is there. It has to be done. So you can enter into the compliance space, which is something which I think many lawyers are forgetting to do, because you see, when you enter into the compliance space and also in the corporation, you help them operate in a very professional way, which makes sure the value of the land is maintained. So that if there's any issue of service charges, if there's any issues of services, any disputes, it can be dealt with before it escalates and makes the community agitated. But technically, as a conveyance lawyer, your work ends when you finish registration and you do what is called a post-registration search, and your work is done. But if you want to continue being part of the project, you just need to do some value addition by now showing them the value that you can bring in terms of dispute resolution, making sure the place is compliant, taxes are paid, everything. Yeah, I think that's the last question I've seen here. So I give it back to you.